Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner with Sumner Immigration Law, and today we're talking about the H-1B1 classification. The H-1B1 classification is different from the H-1B visa classification. We have a previous series of videos on the H-1B classification, and this is a different classification specifically for nationals of Chile and Singapore. There are similarities with the H-1B visa classification, namely the position that a person is coming to work in H-1B1 status for has to be a position or an occupation that requires a minimum of a bachelor's degree in a specific field of study in order to enter that particular profession. In addition, the H-1B1 classification has to have an LCA attached to it, a labor condition application, just like the H-1B petition does. There are some key differences as well. For example, the H-1B1 is only for nationals of Singapore and Chile. To apply, the foreign national can apply directly at the US consulate with the LCA, the support letter from the employer, other required supporting documentation, but they don't have to have a petition approved by USCIS. They do for the H-1B classification. In addition, it is possible for the foreign national to submit a change of status, a extension of status, or a change of employer petition, or rather the employer does that on their behalf within the United States. You would file that with USCIS. However, if you're filing in the United States for a change of employer, change of status, extension of status, it's important to keep in mind that no premium processing is available currently for the H-1B1 classification. In addition, there's no portability. With H-1B, the H-1B classification, there's something called H-1B portability, meaning if, let's say that a person is working for a company A and they want to transfer in H-1B status and they want to transfer to company B, that person can begin working with company B as soon as company B's H-1B petition is received by USCIS, and they can continue working until the petition is adjudicated. That's not the case for H-1B1. The petition has to be approved before the person can begin working for the new company. So that's a key difference. In addition, there's no dual intent for the H-1B1 classification. That refers to the question of pursuing permanent residence at the same time as holding that particular classification. There is dual intent for the H-1B classification. There's not for the H-1B1. That absolutely does not mean that you cannot pursue permanent residence while on H-1B1 status. It does mean that you have to be very strategic and careful with the timing of the permanent residence application while the foreign national, is in H-1B1 status. The H-1B1 visa is valid for up to 18 months, and when a person enters the United States in H-1B1 status, they're admitted for up to 1 year, which is a relatively short period of time, of course. Like the H-1B, there is a numerical limitation on the number of new H-1B1 visas available every year. However, that number is different and the usage is different. So there are 1,400 H-1B1 visas, new visas available each year for nationals of Chile, and 5,400 H-1B1 visas, new visas available every year for citizens of Singapore. So far, knock on wood, there has not been a lottery. You hear lots and lots about the H-1B visa lottery. That's because there's so many people who are applying for the H-1B, but so far there's not been a lottery for the H-1B1 classification. You just apply. Of course, you need to check and make sure their number is still available that year, but in general, there are numbers consistently available. In our next video, we're going to talk about ways to extend the H-1B1 and E3 status or ways to renew those particular visas. Until next time, I'm Emily Sumner.